Hey, welcome back. So today is a little bit of a public service announcement, just based on things that I've seen out there. So if you're somebody out there and you feel like a company has done you wrong, okay, they have failed to deliver on the obligations under a contract, or just somehow caused you harm, your first thought is, let me go talk to an attorney, see what my rights are, see if there's anything I can do to remedy this wrong that's been done to me. And that is a completely valid response. Absolutely, you should do that. But here's what you need to be aware of, be careful of, is that there are attorneys out there that will, for lack of better terms, just sell you a bill of goods. They'll promise you that you're entitled to, money for pain and suffering, and that you're going to get your attorney fees reimbursed to you, and you're going to get punitive damages granted to you, meaning the court's going to want to punish this company for what they've done. And the challenge there is that these attorneys are just promising you the moon, and then you get into litigation and you spend 1.5, 2.5, 3 years of your life grinding through a lawsuit, dealing with discovery and dealing with depositions and court hearings and mediations, where it just feels like it's adding insult to injury. And then finally you'll get to a point where your attorney is gonna essentially push you to settle the case for a fraction of what you thought you were going to receive. And then, to kind of double down on that insult to injury, the attorney's going to take their cut. Maybe they withheld a certain portion to pay the attorney fees until the end, and so at the end you're writing that check for all the work they put into it. Or maybe it's just a percentage. Maybe they're promising you, listen, I'll only take 1/3 of what we eventually recover. That can be pretty painful. You've been through, like I said, a couple of years of litigation, just grinding it out, reliving whatever the wrong that was done to you. You get to the end, you get less than what they promised you to begin with, but you're just so tired and worn out you want to be done anyway. And then finally, you're stroking the attorney a significant portion of that money that you receive, which is even less than what you thought it would be. And that's best case scenario, I think, where you even get money. There's going to be cases where, you're going to hear that dreaded phrase from a plaintiff's attorney called the $0 walk away, meaning, we've gotten to this point, but I think we'll all just walk away, go our separate ways, and call it a day. And in that scenario, you don't get any money, and you might get stuck with an attorney bill. And that can be pretty frustrating. So just some things to look out for, right? So if you get harmed by a company, and let's take personal injury out of this. So this is not talking about if you get hurt in an accident. This is just landscaping companies said they were going to come in, they were going to put evergreen trees in your front yard. The trees they put in either weren't as big as you thought they should be, or they died early, or they're not even evergreen trees, they're some sort of other tree. That kind of scenario where you pay this landscaping company $25,000, you feel like they only did $10,000 worth of work, and you want your 15 grand back. You go talk to an attorney, and that attorney starts throwing out, like I said, words like, punitive damages, pain and suffering, attorney fee reimbursement, and says, look, instead of that $15,000, I can get you $100,000, or I can get you $150,000 back. That should be a red flag. That's a scenario where you're more than likely going to end up grinding it out over a couple of years and not getting what you thought at the end. So just be aware of that. I would say when you're having this conversation with a potential attorney, they start throwing out terms like that, you dive into it, you really dig into the details and find out, why do they think that? Why do they think that your attorney fees will be paid to you on top of whatever damages you should receive? Why does this attorney believe that you'll get punitive damages granted to you? Why does this attorney believe that the court will want to punish the company or the landscaping company in our hypothetical scenario? You know, why does the attorney think you're entitled to pain and suffering damages? You know, pain and suffering damages, that's going to stem from an actual injury. Or a tort. We call it like a negligence tort, something where you've been injured intentionally by somebody else. Whereas if it's a contract claim, there aren't pain and suffering damages. You know, in our landscaping scenario, there aren't pain and suffering damages there. It's just purely, what is your damage as a result of the landscaper not performing their contract? Doesn't have anything to do with your emotional stress. So, you know, dive into that with your attorney and really kind of hold their feet to the fire and make sure they can support the things that they're telling you, so you don't get sold this bill of goods and have an unrealistic expectation and spend the next 3 years in litigation only to be severely let down. And also, I think, is going to give you some insight into their thinking and their success rate. You know, ask them how often they prosecute these types of cases. You know, we see a lot of attorneys out there that convince their clients that every company is, you know, just a bag of money that is going to pay out an easy settlement with very little work and very little time, when unfortunately that is not often the case. So, you know, if you're going to get into litigation with a company, you know, you need to be prepared to go the distance, to kind of go through that grind, go the long haul, understand, you know, your rights, your obligations, understand the best way to enforce those. Make sure you've got an attorney who's done it before and had success and isn't just out there treating, you know, every company out there like, you know, it's just a bag of money to be settled. And instead understand that, you know, litigation, it's an uphill battle. Nobody likes it. It's not comfortable. It is very adversarial. It's very confrontational. It's not something you can avoid if you're going to, you know, have attorneys out there suing companies. So, you know, you as a client just need to be aware of what you're signing up for, and just, you know, don't fall for those bills of goods where you're getting promised the sky. I mean, understand that that's not where you're going to end up. So my 2 cents, you know, you're looking for attorneys who are, you know, more reasonable, middle of the road, understand the claims, aren't trying to, you know, overpromise and underdeliver, and instead are giving you just a reasonable, you know, a reasonable path forward about how to get your injury resolved. And in many cases, you know, you have attorneys out there that can do that and will do that. And at that point, it's more or less just facilitating that resolution, you know, rather than the attorney kind of becoming the star of the show. So you're looking to avoid that. And yeah, I think that, you know, hopefully will save some of you folks a lot of time, a lot of money, a lot of frustration, and you know, prevent you from, you know, finding yourself in a court case or a mediation hearing where your attorney is just, you know, kind of off the rails on what they've promised you. So, all right, good luck.